Hello, everybody. Welcome to our webinar today. My name is Joey Barnett, and you are listening to our EB-5 Sustainment Derangement, updates and answers to common questions about the at-risk requirement. EB-5 is a investment-based visa and the way to get a green card into the United States, as many of you know. The question that should be easy to answer, which is a little bit more difficult than it should be, is, well, how long does the investment actually need to remain in the EB-5 project? And unfortunately, that answer depends on when you filed your EB-5 case. And we are going to be getting into the nitty-gritty on this today. So thank you so much for joining. This is live, so if you do have questions, you should be able to put them into the chat, and we will try to answer them during the webinar, or if not, at the end. And we are very, very happy to have you here. So my name is Joey Barnett. I'm a partner at WR Immigration. I'm located in Los Angeles, California. I've been practicing EB-5 for about 13 years, and I am now the vice chair of the AILA's EB-5 committee, and we are one of the top EB-5 firms in the United States. We have filed over 5,000 of these EB-5 petitions for thousands of investors, and we are very much on the cutting edge and happy to have you here. I am joined by two people in the EB-5 community, Michael Gibson and Ishaan Khanna, who I've known for a long time. I respect both of them a lot. They come from very different backgrounds. I'm going to let them give themselves their own introduction. But I want to say that I've known Michael for over a decade. I've always respected his thoughts and the way that he does his services. Ishaan actually was a client of our firms. We helped him get his green card through EB-5. And since then, he has really moved on and up and is now a mover and a shaker in the EB-5 world. And we are very, very happy to have them on. So, Michael, why don't you just give us a little background about yourself and what you do with EB-5?
Yeah, thank you so much, Joey. And I appreciate the work that you and Bernie do, always leading lights in the industry. And your constant updates and webinars are very informative and should be watched by everybody who's a practitioner. It's very interesting and, to the point. So my background comes from investment banking, over 20 years with Citicorp, capital markets, mostly emerging markets around the world. I came to EB-5 over 15 years ago, working with an immigration attorney who had clients who were asking questions about different projects. And at that point, using my investment banking background, decided to set the Pre-RIA, which is a registered investment advisory firm. We specialize in doing verification and due diligence for investors deciding on which project to invest in, so that they can choose the least risky one. And I know we'll talk about this, but we've been getting a lot of questions regarding the changes from the RIA and how that affects the pre-RIA investors. And I know we'll talk about that, but I wanted to thank you for inviting me to come on to this program so that we could discuss some options for investors who have invested previously pre-RIA and explain what their options may be.
Excellent. And you actually approached us to talk about this. And I apologize for the technological stuff here. You actually approached us to have this conversation because a lot of people reach out to you, either both pre-RIA or post-RIA, and they're trying to figure out, hey, how can I get my green card the fastest? Right? I mean, and so for some of these folks who are filed pre-RIA and are stuck in these visa backlogs, USCIS's guidance on their sustainment, and we're going to get into this, it hasn't even started yet because they haven't gotten their conditional green card. And so we're going to be talking further on about, hey, do you stay in your current offering, or are you want to move and try to do something separate post-RIA, and maybe you're going to be able to get your green card a little bit faster?
Exactly, Joey. And so we're running the EB5projects.com portal. And of course, we get a lot of questions, not only from investors, but their attorneys, CPAs, regarding what can they do? Their clients have been in holding. They may be stuck in these investments, now redeployed several times for 5, 10 years or longer. And their clients are getting desperate, to be honest. And I think there's a bit of misinformation out there. And I reached out to you because I know you have a large platform to try to answer some questions that we've been getting and help you and Ishaan provide your expert insight into these questions and how they may be able to navigate getting a better result.
Excellent. Thank you. And Ishaan, why don't you give us a little bit of a background, both from sort of your personal background and then professional as well?
Sure. So first and foremost, I am an EB-5 investor. My name is Ishaan. I did EB-5 in 2016. I'm originally from New Delhi, but now I live in Washington, D.C. Me and a group of other investors, we actually started a nonprofit that advocates for EB-5 investors. That's really our main goal, is to advocate and protect their interests. Redeployment and the sustainment period is an issue that I have been, quite passionate about for many, many years. I think it's, very unfair to begin with, even though many people out there will disagree with me. I personally, I'm the same, I have the same views as Michael, which is I think it's important for people to have the information and understand exactly the impact of the sustainment period and redeployment before they get into EB-5. And even after they've invested. Quite often you can invest in project A and then a few years later find out that your money has now been moved to project B without having given consent or even analyzed this new project that your money's gone into. So anyway, that's kind of my background. Professionally, I continue to work in the EB-5 industry. I've been in the EB-5 world for the last several years. I've raised about $100 million plus of EB-5 financing across a number of different asset classes all over the world. I mainly work with investors based out of here in the US, especially those of you that might be stuck in the EB-2, EB-3 backlog, and will likely continue to do that for a while.
Excellent. And can you give us a little bit of background as well, just about your nonprofit that you lead as well?
Sure. So the nonprofit really came about because me and a group of other investors just felt like that there was really no voice for us, whether it was in Congress or just in the EB-5 ecosystem. I think, EB-5 investors truly make the foundation of this entire industry. I believe everybody here on this call, including myself, we really get a paycheck at the end of the day because of the hard work that investors have put in to earn their money and actually invested into this program. So I believe advocating for them and advocating for their interests is paramount for all of us. And so my organization, we initially started because the program lapsed. The EB-5 Regional Center program actually lapsed at one point of time. We fought for the grandfathering of everyone that had already invested. To be told, we weren't so focused on what the future of the program was. We just wanted everyone who's already invested for them to get the fair deal, which is they invest the money into the US economy, their money helps create jobs, and they get a green card. That's it. And so that's what we've constantly advocated for. Over the years now, since the program has come back, we've continued our advocacy efforts. We do a lot of work in terms of investor education, educating those who have already invested, perhaps those that have, lost their money or have been defrauded. We do a lot in terms of ensuring those investors have resources and tools and know who the right people are to talk to. And similarly, we've now continued our work in Congress and in the courts as well. We have sued USCIS multiple times. We have tried to get data from them that's been hidden away. In fact, I see one of the attorneys that we worked with to obtain some of this data on the call today. Hey, Austin. And, we continue to basically do work in this space to advocate for investors and ensure that they are well informed before the investment, during the investment, and even after they, may have got their permanent green card. There are plenty of investors out there who finished this process successfully, but have yet to receive their money back. And I think a lot of investors don't realize, but the US government doesn't actually care if investors don't get their money back. We want to ensure that for those folks who are in that situation, just have, again, the tools and resources they need to feel secure in this process and feel like someone has their back. So we are a 501c4 nonprofit. We do rely thoroughly on donations from investors and the EB-5 community to keep us going. So, hey, if you like the stuff, hopefully, and you like our mission, please do consider donating to us.
And I wouldn't say that the government doesn't care if investors don't get their money back. It's not a legal requirement for them to get their money back in order for them to get the full immigration benefit. So,
right.
Yeah.
SEC is,
Yeah. All right. So again, my name is Joey Barnett. We have a monthly Chatting with Charlie Oppenheim, who used to write the Visa Bulletin at the Department of State. I kind of eat, sleep, and breathe EB-5. I see everybody on here. I think I know most of you. Thank you so much for listening in. We're also going to be posting this on YouTube, and you can be able to get a recording of it later. As we always say, this does not constitute legal advice. It's just for informational purposes. But if you have a case-specific question or want to schedule a consultation, please feel free to reach out. You could do it at visalaw@woolstorff.com. My email is jbarnett@woolstorff.com. WR Immigration, we are a top immigration law firm. We have over 10 offices. We have over 40 attorneys, over 150 staff members. We are very much on the cutting edge, and we would be happy to help you with EB-5 or any other type of U.S. immigration. So let's get right into it. This is the overview and where we're going to be going as we go through it. And really, let's just jump right into it. And I want to start with the law. I know that's a little boring, but I think that's where we should start. This was the law before the RIA was passed. It said that the I-829 must include information showing that the capital was sustained throughout the period of the alien's residence. At that time, and really through 2017, we didn't really know what that meant. Was it the first 2 years of their conditional green card status? Was it until the conditions are removed? It was unclear. And because of that, a lot of the offerings that were put out in the market before 2017 would have the money stay into the project until the person had their conditions on their green card removed. Or potentially all individuals in their NCE had the conditions on their green cards removed. And that is very specific based on every investor's circumstance. And so people's money would just sort of be stuck for a while. Now, the regulations at that time did say over the 2 years of conditional residency. And there was a little bit of a gray area there. And I always thought it was very clear that the regulation said, no, only the first 2 years of your conditional residency. But regional centers, developers, attorneys were being conservative. They wanted to make sure that the I-526s could get approved. They want to make sure that the I-829s for all of their investors got approved. And so we kind of had these long investment terms, which were a little bit different than maybe what was in the marketing material. Michael or Ishaan, do you guys have any thoughts on, I mean, I know we're going way back when, but do you have any thoughts on that and sort of the thought of an investor? I mean, Ishaan, that's when you were looking into doing EB-5, right?
Yeah, in fact, when I did it in 2016, it wasn't so much of a concern. In fact, I don't think at that point, even the Chinese who really had the biggest backlog at that point of time were even aware that, redeployment and this whole sustainment period was going to be an issue. I do think it's unfair for a lot of those investors who continue to then invest in 2017, 18, 19, and maybe weren't totally informed that, hey, you may not get your money back at the time when you expected to, even if your project is successful. I think this actually becomes an even bigger issue when you start looking at the people, especially the bulk of people that invested in 2020, 2021, which was a lot of Indian investors. Many of them, I think, at least when I was talking to many of them, I let them know that, hey, look, there may be a chance of a backlog. And this will not only impact how long it takes for you to get your conditional green card, but could potentially impact when you get your money back. And not just when you get your money back, but the potential risk of now having your money being reinvested somewhere else. Then, there was COVID, the program lapse, and there were so many things that actually delayed the process for so many people. We're at a point now where even if you aren't from a backlog country, I personally know investors that invested in 2019, 2020, who took almost 3 or 4 years to get their conditional green card and have now been in a situation where their money has now been moved from one project to another.
Right. Joey, just to add to Ishaan's point, you're absolutely right. I think everybody in the industry got caught by surprise. I don't think this was something that people really saw coming. When I first started, the 526s were getting approved in 30 days, 60 days. And that was, well, there was a handful of regional centers, maybe 12 regional centers. Now it's obviously very changed. And due to all the things that Ishaan just described, I think these problems with country caps being hit, with the visa backlog, with USCIS processing, which has been a nightmare for years, I think a lot of that just compounded to make the situation to what it is today, which is a nightmare for many, many investors.
Right. And in 2017, USCIS put together a policy manual, and now it's a footnote in the EB-5 policy manual online. And this is what the law is today for pre-RIA investors. Your money must remain at risk, sustained within the new commercial enterprise for the first 2 years of conditional green card status. If you get a cent back before the end of that 2-year period, they will deny your I-829 because they will say that your money has not been at risk. And so this gets to Ishaan's point of, well, what happens if the loan is repaid? If you haven't met that 2-year period, then yeah, there's a requirement in certain circumstances where the money needs to be redeployed and go into another project. And USCIS's guidance on this has sort of changed over a period of time, but that's where it's at. You do not need to keep a cent in the new commercial enterprise after the 2-year period has passed and have no impact on your immigration status. Now, whether or not you're going to get your money back at that point obviously depends on the viability of the project. It depends on the loan agreement. It depends on the redeployment terms that have either been agreed or consented to, or perhaps not. But that is where we are at right now for pre-RIA investors. And the big problem, as we've been talking about, is these visa backlogs. They didn't really come into place for China until 2014. And then I don't think for India and Vietnam until, well, Ishaan, do you have an idea? I think it's like 2017 or 18 is when there might have been some issues with India starting to come into place. But the main point is that if a visa isn't available and the U.S. consulate isn't able to issue a visa, or if you're in the United States and USCIS isn't able to adjudicate your adjustment of status because a visa isn't available, then you cannot start your conditional green card status. And that is the trigger for you to begin that 2-year period before you can get your money back. So, Michael, can you give me sort of like a common example of somebody who would have approached you and what they're kind of dealing with here? And I kind of written it out here, but just like a typical phone call that you would get from a Chinese investor who filed in 2018.
Right, Joey. So the issue is affecting, well, let me start out by saying the change, the Post-RIA change that in the Reauthorization Act is revolutionary. It's monumental. And the main concept that people need to grasp is that the control now went from the partnerships, the general partnerships, the investments, whatever the NCE structure was, went from them or USCIS to adjudication, to consular processing, which was all out of the investor's hands. The investor had no ability to control any of that. The control has now shifted from other third parties. Now it's back potentially in the investor's hands, where if they choose correctly, choose wisely, they can invest in a project and have all of their immigration requirements satisfied within 2-year period. And we're going to use the 2-year time frame kind of in quotes, because the milestones to achieve that 2-year sustainment period can be a little bit technical, from when the money enters the NCE to when it's deployed to the JCE to when the JCE may actually spend it. And I would refer anybody who's listening, if you haven't already read Suzanne Lizicki's excellent article on milestones and timelines, to refer to that. It's a great explainer. But the point is this: the control has shifted from third parties who manage the investment and the adjudication to achieve CPR to now back to the investor, who, if they choose, can invest in a new project and achieve all of the immigration requirements within 2 years, Whereas now they're stuck in a holding pattern. So Joey, to answer your question, the question is, typically we get from an investor or their attorney, I have a client and they've been invested in X project for 5 years, 10 years or longer, and they are beyond frustrated. They want to get out. What can they do to get out? And unfortunately, typically what the GPs have been saying is that because you're a limited partner, you have no control over what you can do. But that's not true. And I know we'll talk about it later, but the main point I want to emphasize is that the typical question we get is, what can they do? What options are available to them? And I reply, well, you have options, and perhaps we can explore those.
Well, actually, I think this is kind of a good segue. Let's stick with the pre-RIA investors for the time being, and then go to post-RIA. But when USCIS came with the post-RIA guidance saying, "Oh no, it's not based on your conditional residency. It's about when the money is being made available to the job-creating entity and spent, right, and made sufficiently at risk in compliance with EB-5 guidance." Pre-RIA investors were saying, "Oh, does that apply to me now?" And the answer, unfortunately, is no. And so they're thinking, wait, so people who are applying after me are going to potentially get their money back before I did, even though I invested years and years beforehand? And they see that as unfair treatment from USCIS, and they're looking for options in order to get their green card benefit and their money back a little bit earlier. So on this screen that we have here, I'm just thinking about a Chinese investor who filed in 2017 or after. Right now, based on the data that we have from the National Visa Center, and I'm going to do my best to put my Charlie Oppenheim hat on here, is that we have nearly 20,000 visa applicants with priority dates in 2016 and 2017. And so the way that China has been able to get so many visa numbers over the years is these otherwise unused visa numbers from rest of world. They are not being used, and so they get allocated towards EB-5 investors with the earliest priority dates. Those have been historically Chinese over the past 8 years or so. But even if China gets over 50% of those unreserved visa numbers, it can take potentially up to 6 years for the China final action date unreserved to reach January of 2018. So if you filed in 2018 or afterwards and you're Chinese, it's going to be a bit of time still before you are able to get your conditional green card. Now, if rest of world demand continues to go down because USCIS clears out the queue, or the consulates start issuing more visas and there's just less demand for them, that means more otherwise unused will go to China, and maybe that percentage will go up and this weight that I mentioned will go down. Again, it's sort of depends on what happens at the consular level as well with USCIS. I do think it's less of an issue for Indian and Vietnam investors who have in the past been subject to a final action date in EB-5. And that's just based on the number of folks who are waiting for consular processing and the actual annual visa limit for unreserved. And so I tend to see this redeployment, am I going to come out? Should I try to exit? As mostly a China EB-5 issue, although there are obviously specific cases where it can impact other nationalities.
I think it does. Mainly, like, for example, if you're maybe a Q3 or Q4 2021 EB-5 investor born in India, I could see this being a real issue for you because, I mean, just from the rough calculation we've done, or at least my nonprofit, the data we've gotten as we've sort of analyzed it, we think that it could, again, be like a few years at least until the final action date becomes current to that. And maybe that could change, right? Maybe people will get denied. Maybe people will drop out. So that could all have its own factors. But there is a question, there is a concern there. If you're an EB-5 investor who invested at that point of time, you're staring at the backlog, you may want to consider pulling your money out if you can, and then reinvesting it in a new post-RIA project where you're more likely to get your immigration benefits right away if you're in the US. You may even get your money back sooner because you won't have to face redeployment. And you may even get your conditional green card quicker as well. So those are all, matters to consider if you are in that boat. I hate saying this out loud because I understand that investors out there who are like, wow, I just made a investment earlier. Maybe I made it at $900,000 or something like that. Now I'm going to have to come in again and make another investment, start the whole process all over again. Yes, I realize it's a hard ask, but it is something to consider if you're in that boat and if you mind the wait.
Right. And Michael put together this great slide here because the question really becomes, do you stay in your current new commercial enterprise that's probably been approved at this point, but you're waiting in the visa backlog? Or do you try to exit, use some of that money, or maybe invest other money and go into a new regional center project where there's a shorter wait time for both the green card and the investment back? But really the question is how do you do that? How do you get the money back from the new commercial enterprise that's the basis for your initial I-526? And generally, you can't just write the NCE and say, hey, I'd like my money back. The money is likely deployed into the project, right? And there are contracts and terms about the repayment of that. And so, also, just because you file an I-526 withdrawal, like, hey USCIS, I'm withdrawing this, please don't consider this anymore. That does not by itself give you the ability to get the money back from the project. And so, Michael, this is something that I know you're very in depth with. Can you kind of give us a little bit of information about how that would happen, I guess, more from like a technical point of view?
Yeah, Jillian, you hit the nail on the head. That it's and Ishaan referred to this as well. It's extremely unfair. It's so unfair to pre-RIA investors that post-RIA investors are going to resolve their sustainment period requirement so much faster. It's very sad and it's unfortunate, but that's the world that we live in. And so to give some hope, some glimmer of hope to the tens of thousands of pre-RIA investors, what can you do? And you may be Indian, Vietnamese, it doesn't really matter. You could be stuck in one of these redeployment loops that Ishaan has mentioned, and you don't even know where your money is. I know a lot of the GPs are not exactly the most communicative, and they're saying, well, it's our decision to deploy your money here, there, and everywhere, and you have no control over that. And you may not even get your money back, which is, of course, the tenet of EB-5, that it's at risk. But the sad part is it may not even satisfy the CPR requirements. So, Joey, knowing that, what do you say to if you're an immigration attorney, what do you say to your client who's stuck in that loop? Well, there is an option. You can sell or try to sell your limited partnership interest to try to recoup some of the money invested, knowing upfront that, one, it's going to cost. There's no upside to this process, other than the fact that you can move into a new investment, hopefully recoup some of your past investment, move that into a new NCE, and then hopefully achieve all of the new sustainment requirements in a much faster way. So how does that work? So unfortunately, limited partners, as everybody knows, have very limited power, almost none, to be specific. And you're right. They cannot simply write to the NCE or the project manager, the GP, and say, I want my money back. That typically is going to lead to, no luck. We're not going to refund your money. And it may be for a number of different reasons. The money may be tied up in a redeployment. It could be in a completely different structure. It could be subordinate to a number of other forms of capital and equity in the stack. So the GP may not be able to refund your money, which is oftentimes the case. However, there is a third-party solution in the private markets, whereas if an investor is interested in exiting their limited partnership, they can reach out and we can put them in touch with private investors who are willing to buy their limited partnership interest, and they will do this for a price. So A typical, let's say, investment before 500,000, the investor could be stuck in this loop. They don't even know where their money is. They can come to one of these private investor groups and say, I have this position, I have, and they provide offering documents and whatever documentation. And they say, what is this worth for you to give to me so I can try to recoup some of my investment and let you take the burden of wondering if I'm ever going to get repaid or not. And these groups will give them a price. So it may be 50 cents on the dollar, it could be 70 cents. It really depends on what the investment is currently in and, when do they think the maturity date is. That's a topic for another day as to what is the value of their current investment. The good news is there are private market solutions that these groups will take and repay the limited partner, and then they can take that money, put it into a new investment, or maybe just exit EB-5 altogether if they're that frustrated. But there are private market solutions. And the better thing for the general partners is what I would say, we hear a lot of pushback from the GPs saying, no. We don't want the LP to exit. That's going to screw up our whole partnership agreement with all the other investors. It may affect their conditional status, and we don't want to do that. But the truth is, it's only a book entry. No capital is actually moving. So from the standpoint of USCIS, if they're looking at sustainment and capital invested into the NCE, then to the JCE, no capital actually moves. All that happens in some book is in some journal is a book entry replacing the EB-5 investor with a private group investor, and that's it. The capital remains sustained for everybody else in the pool.
And you would be able to connect investors with these private parties? Is that part of your role, right? That's something
Yes,
you can help with.
Yes, we actually have these groups coming to us, and they say, they're interested. There's a market for this, and this has been done many, many times before in many different partnerships where they come in, they will buy the existing partner's interest. Again, there's going to be a discount. There's no way of getting around it. You don't want to sugarcoat it. You have to be very upfront with your client and say to them, listen, you invested $500,000. First of all, chances are you may never get repaid a dime. And that's the honest truth. And we've seen that in hundreds of projects where they never get repaid at all. But if you're interested in exiting, these people will give you a price, and there's no fee for that. They can simply provide us with the documents. We will then take it to the third-party broker. They will come back with a price, and your client can accept it, not accept it, do whatever it wants, but at least it gives them the option of saying, yeah, I'll recoup part of my investment, maybe redeploy it, put it into a new Post-RIA NCE, or do whatever with it, but at least it gives them an option to try to exit without having to deal with, waiting 10 more years or longer for a resolution from whatever redeployment cycle they're in.
Right. Thank you. That's very helpful and an option that I don't think a lot of people know about. So I'm glad that you are able to give us some information about it. To answer some more questions on this slide, yes, you would need to file a new I-526E if you were going into a new project following an exit from the prior project. Once you get the money back from the initial project, that is sort of the end of your initial EB-5 case, because your money is no longer at risk throughout the sustainment period, right? So by doing this, you are shutting down your initial EB-5 case and you're moving forward with a new one. Now, if you have other money that you want to invest, there is nothing stopping you from doing just a straight new investment, keeping your money in the old NCE, moving forward there, as well as doing a new post-RIA investment and trying to get the green card through that process as well. So there is nothing stopping being in two lines there.
The point I would make there, you're right. Once they get their money, once they've exited the partnership, that terminates their pre-RIA petition status. They're no longer eligible because they haven't even begun conditional residency. The point here is that this is the scenario that I would paint, and again, it goes back to being unfortunate for pre-RIA investors. But if they were to do this strategy, think about this. They could invest wisely into a project that will deploy the funds upon receipt in the NCE into the JCE within a very timely period. And hopefully the JCE then begins expending that so that they meet the sustainment period. But the timeline could be that within 2 years or so, 2 to 3 years after investment into the new vehicle, they could have achieved the 526 approval, the sustainment period, and again, depending on 829 processing times, they could have achieved all of that before their pre-RIA investment, before they achieved conditional, admittance into the United States or an AOS. So all of that could occur with this other strategy of their own redeployment into a post-RIA investment.
Nice. I mean, I know, Ishaan, you at AIIA have written extensively about the struggles of redeployment for these pre-RIA investors. I do want to stop sharing my screen so that you can pull up what you have put together. And again, this is just a pitch for folks who are learning about this possibility. I really respect Ishaan and AIA's sort of advocacy here for pre-RIA investors. And so, Ishaan, do you want to give us just a little bit of information about what you had tried to do with the RIA and everything like that up to the passing of the RIA? And I guess since then?
Sure. So, I mean, just to give a little bit more history before I start sharing this article. So we actually have been, again, against the practice of redeployment for a long time. It just doesn't make sense for an investor to invest their money into project A, where the money is spent, the jobs are created, and then their money to then be reinvested into a new project. That sort of, it just goes against, I think, the true intention of the EB-5 program. Some people will claim that it devalues American permanent residency, but I don't think that's legit. The fact remains is that, we as immigrants in this country just want a fair deal, right? We want the US economy to do well. We want projects to be created which create valuable jobs, and we want permanent residency. And a lot of us immigrants are okay with getting a minimum return on investment. But then to jeopardize their investment and take their money and put into another deal, I think that entire concept is flawed to begin with. And people can argue like, okay, what if a project finishes early or something like that? That's great. That's wonderful. You created the jobs. Your project got done. It's in a position to repay its investors early. That's fantastic. Let that happen. So that's what I'll say is sort of the history behind it. And so when the program this regional center program lapsed and this new program was coming up, we did push Congress. Our lobbyist was advocating to members of staff and saying that, hey, this redeployment, this system is unfair. And we had our voices heard. And we had actually pushed for certain provisions to be added in. There was a point of time when the regional centers actually had a dedicated such section on redeployment in the bill. We actually pushed for protections on that too. We said investors should at least, at the very minimum, be able to provide consent before their money is redeployed. Now, those provisions didn't make it in, but instead we got something else. We did get a new provision, and Joey and I will get into that later, which is the provisions for post-RIA investors, which is now essentially if an investor was to invest today, their sustainment period clock does not begin with the conditional green card, which is the case for pre-RIA investors, but now that clock begins when the investor's last dollar is put into the JCE, the job creating entity. So with that said, it's not like the problem hasn't gone away for pre-RIA investors. In fact, one of the articles that we published soon after this program was soon after the new program came into effect, was this thing called the nightmare that is redeployment. This is something that I spent months and months drafting. And, this is something, again, which has been on my mind since the day I started working in EB-5. Just this really unfair system, this sword of Damocles sort of hanging over each investor's head. So we explained what exactly is redeployment. We talked about its history, how exactly it came to be. What's funny is that people don't realize that redeployment just came out of a USCIS policy manual issue. In fact, the government actually admitted in a recent Q&A that back then in 2015, 2016, 2017, they had never realized that this would ever be an issue. They didn't expect these backlogs, these visa backlogs and all to come about. So, we've done a full deep dive into this policy. We've talked about the impact of it. Now, we've also explained why exactly it's such a problem for investors. There have been situations in the past and even today where investors' money has been reinvested into a new project, and those projects have failed and they have not been good. In fact, there is a sort of almost a hidden practice out there of regional centers presenting project A to investors and doing a quote unquote early repayment only to have their money actually reinvested into the project that the regional center actually wanted their money to go into. And how much is this money that's essentially in a redeployment cycle? We estimate it to be around $23 billion. Not million, 23 billion. So it's a lot of investors' money that has the potential to be reinvested and redeployed over the next decade almost. So we talk a little bit about what we're doing to challenge this. We can, in fact, now with the Chevron decision, we're actually considering maybe pursuing that in court for pre-RIA investors. And we try to give information to folks as to what to do at this point of time, whether it's keeping written records from the regional center. There are regional centers that have claimed that they will take consent from investors before redeploying it. I believe all investment issuers should be upheld to that standard. So yeah, I think that's all I can say as far as the pre-RIA investors goes. For those of you immigration attorneys, investors, and other stakeholders who are interested in joining us on this battle, and at least I think is being on the right side of history, do feel free to support us on this.
Before we get into the post-RIA stuff, Michael, there's a question specifically for you. Are these private parties in the secondary market? Are they broker-dealer, private equity firms? What kind of vetting have you conducted, and how quickly does the liquidity event occur?
That's a great question. So it ranges. I mean, look, there's not a huge market, let's be honest, about firms interested in purchasing EB-5 limited partnerships. It's not the public equity market. It's not the Dow Jones. It's not huge, and it's not very liquid. So the chances are you're only going to get maybe one quote or two at the most. The groups are typically very wealthy private investors who've done this before, and they are just interested in getting in, and obviously they want a good deal. And I don't want to sugarcoat this. This isn't going to be you put in 500,000, you're going to get back 450,000. That's not going to happen. But there are groups that will. I mean, you don't want to lose the entire 500,000. And if you are interested in exiting, what I would recommend, honestly, the proof is in the pudding. If you provide them with all the documentation and they come back to you and give you a number, there's no obligation until the funds hit your account. So you can sign an agreement with them. Let's say you get paid $250,000. Once the funds hit, then the limited partnership is transferred. And that's the proof. So I think that's the due diligence that I would go by, as I said, this has happened in dozens of cases. It's happened before. I know there's other people probably on this call who know about this personally, who have set up limited partnerships and have had clients exit for whatever reason. So it has been done. It's not a liquid market. The prices your clients are going to get are not going to be great, but they're not going to be zero either.
Thank you. All right. I do want to save some time for some question and answers, and we haven't even gotten into the post-RIA stuff. But the post-RIA law was changed, and here is sort of a highlight of what was taken out of the law as it relates to the I-829 requirement. And you can see very clearly that the term sustained has been deleted. And instead, what it now says is, and they came out with guidance on this, I believe it was in October of last year, is what they say is your money must remain sustained for the 2-year period after the full amount of the money has been placed at risk, including being made available to the job creating entity. And so if you're doing a partial payment, it doesn't start until the full 800K has been made available all the way to the JCE. It's not when you file. It's not when your money is released from escrow, if it's an escrow. And potentially, USCIS could potentially even say it may not even occur when the money is transferred to the JCE. The JCE has to spend it for it to be at risk. We haven't really gotten any clarity on that, but that is what starts the clock. It's, in my opinion, it's the JCE spending the money. That is what starts the 2-year period before you can get the money back. Now, we're not going to be talking about viability of 2-year investment real estate projects versus 5-year versus longer, whatever it is. That's sort of besides the point. That is an investment decision. We're talking more about what the immigration law requires. So I'm not going to get to that. But this is something that, as we've been speaking about, is incredibly beneficial for post-RIA investors. And I think one of the big reasons why it had such a big demand, not only are you getting a green card faster, but you don't have to keep your money in for as long as the project kind of continues. Now, if jobs aren't created and the money is returned, there are different requirements. And so every case is a little bit different. But overall, I think this is a good policy for immigrant investors. And so some of the common questions that I think you may want to be considering if you are an immigrant investor when you're reviewing different projects, is, well, when is the money going to actually make it all the way to the JCE? And you want to make sure that the JCE spends the money before construction expenditures are done, because then you clearly can show that the money was used for job creation purposes. And these other questions here about, when funds can be returned and is it realistic to be returned within, a 2-year period? Those are real considerations, investment, financial considerations that people need to really evaluate and not just take, a regional center or developer's word at. They have to do their own analysis. I mean, I think what I've seen, and Ishaan, I kind of want you to talk about this, is we generally would have seen anywhere like before the RIA, maybe a 5-year loan term with a couple of extensions and things like that. Now we're starting to see shorter loan terms because of this change in the legal requirement. But then there are also sort of extensions that are being used at the option of the borrower, right? So it's like a 3-year loan, but they have 4 1-year extensions, right? For example, I'm just making this up. So is there any incentive for the developer to not extend the loan on their end? I mean, in what circumstance would they not want to extend their loan and instead repay the NCE?
So this is a pretty complicated question. I mean, there's so many layers to it, but I think it's a really good question to ask. And I think if there's any investment issuers or developers on the call, it's worth for you to consider it, right? Especially if you're out there maybe soliciting investors for your project. How do you create an offering that is marketable, that works for your developer, that works for the people who are spending the money, but also is attractive enough for an investor to invest in? I mean, and there's no secret that there are projects out there which are from major regional centers, which promise to repay within 3 years or 4 years. There are projects out there which have a 3+1+1 term, for example, I've seen. I mean, they're basically 5-year terms, right? Whichever way you look at it, it's more likely than not that the developer will take those extensions. But how do you make it, how do you make this all work? I think there's different ways. So for example, if you are building a project which is able to return its funds early, maybe you're, say, building homes for sale, then it is possible that perhaps when all the homes get sold, the investors can get their money back. Another way to sort of incentivize a developer to return funds is to ensure that whenever they take an extension, they have to pay a higher interest and make it worthwhile for the investor too. If a project term goes beyond what the investor expects, then ensure that they are getting a high yield. I suppose there's different ways to structure this at the end of the day. So, and I also I want to sort of touch upon the argument is that, a 2-year term doesn't work, right? This is something that many regional centers and issuers will argue. Yes, that's true. From a real estate development perspective, a 2-year term doesn't really make sense. You can't, invest money and then expect a project to repay within 2 years. But remember, it's important to remember that it's a USCIS requirement. The minimum is 2 years. There's no ceiling. There's no recommendation. USCIS simply says that once the investor's money has been put into the JCE, has been put into the project, it's the 2-year clock starts from that point onwards. So if you have an offering that's compelling enough, that is marketable, there's no doubt it will sell, whether it's going to repay in 4 years, 5 years, or 7 years. I think it's up to the issuer and the regional center to respond to the market and give the investors what they are looking for. So I think that's probably one way to respond to it. Is there anything else I should cover on this?
No, I like that. I mean, from my point of view, I feel like money talks, and a developer will probably more likely keep money if it's cheaper, right? And so if you have interest rates going up because of they keep on doing extensions, hey, maybe they can get financing elsewhere that's cheaper, and that would give them an incentive to pay the EB-5 money back potentially quicker. Again, these are things that it's very, very case specific and something that should be evaluated before making the investment decision.
And I think also, like, for the investor, it's up to them to make that due diligence. I know some investors, like for example from Nigeria, that are very comfortable investing in oil and gas deals. Look, oil and gas, it's a commodity. It's risky. I, as an investor, probably won't invest in it, but I know there are investors out there which are very sophisticated and understand this market very well. So they could potentially invest in an oil and gas EB-5 project and likely get their money back way, way quicker than a typical real estate deal will. And I think that's the beauty of this country, right? This is a free market economy. There are options out there for people to choose and invest from. And I don't think any of us will ever endorse a risky project, and I don't think many of us can. But it is up to the investor to do that due diligence, make that choice, or give Michael a call and say, "Hey, help us find a good deal."
Exactly. Okay, cool. Michael, any other thoughts for post-RIA investors to consider?
Not. I think Ishaan covered it very well. This is going to be, I think, probably my final comment for the session. And it's a message to the regional center operators. I know on this call, there's a number of regional center managers, attorneys who represent them, and other issuers, developers. Here's my suggestion to you. And realizing this, there is a tension, a dynamic between limited partners and GPs. The GP is responsible for the entire pool, and the LP may not realize they just want their green card. They want to get their money back. But the GP is responsible for maintaining the investment until all of the LPs satisfy their conditions. So I don't blame the GP for being stuck in this position. This is unfortunate for a lot of regional centers. They got caught with this time issue problem of having to maintain. Redeployment's a nightmare, I think, for everybody. It certainly hurt investors the most, but the regional centers have had a lot to deal with to try to maintain the general partnership. So here's my suggestion or recommendation. I would recommend to all the regional center operators who have pre-RIA investors to send them a letter and work with your immigration counsel. I know Joey represents a number of or has regional center clients. I would send all of the pre-RIA investors a letter saying, do you want to exit? No questions asked. Just tell us yes or no. Are you interested in trying to recoup some of your investment? You're not going to be made whole, but we can maintain the general partnership by bringing in one of these third-party investment firms. And you may come back with 10 or 20 investors who say, I'd love to get some of my money back. I don't care. I'm just fed up. And then they could contact us or contact one of these third-party institutions and say, we have 20 investors in this group. They're currently invested in such and such. Here's all the documentation. Let this equity group come back to you and give you a price for all of the investors who want to exit and have them exit. Not only that, but here's another suggestion. They could then take all of the money that they're going to reinvest and put it into your current project. You can give them the option. We've been nice to you. We through this third party, it's not our money. We're going to refund, whatever 50% or whatever it is of your money. And if you're interested, you can reinvest in our current project and then maybe give them a sweetener to do the whole deal. Anyway, the point is that this doesn't have to be a lose-lose for anybody. Obviously, the pre-RIA investor may lose some of their principal invested, but they get out of the holding pattern. The GP can have happy investors now. They're not going to be faced any potential litigation from LPs trying to get out. And then they may get the added benefit of having all of this new money at $800,000 or more come into their current project. So I think there's a kind of a win-win solution if we're recognizing that USCIS is inefficient and consular processing and backlogs and all that exist, that could offer a solution for everybody.
Excellent. I really appreciate that perspective and that insight. And, it's a conversation that I think investors are having internally. I don't know how much they're really having it with regional centers at this point, but it is something that I know a lot of clients are, they're saying, well, hey, it was a 5-year loan. Are you telling me now that I still can't get my money back? And it's like, well, yeah, because you haven't gotten your conditional green card yet. Like that's what the immigration law requires. But it is great to see that there are some options that exist. And yeah, it's going to be a little bit of, there's going to be some costs involved. There's going to be potentially some headaches involved with going through the actual mechanics of the process, but it is a pathway forward. And so that's what I really wanted this webinar to be able to discuss. Ishaan, any final comments from you?
No, I think I think all the points have been covered. I'd say if you are a post-RIA investor, the new laws are great. It's in your favor. Keep an eye on your project. Ensure that, the money is being spent correctly and that your jobs are being created. And hopefully, as long as you invested in a good project, you should get your money back as well and your green card. If you are a pre-RIA investor, not just keep an eye on your investment, but ensure that your immigration process is happening quickly. Keep in mind that your immigration process can impact how soon you get your money back. If you are facing delays throughout your process, maybe consider reaching out to Joey and asking him what a writ of mandamus is. It's something that I also filed at one point of time to get my green card faster. So look into everything, be informed about this process. This isn't the type of investment you can just set and forget. So it's important that every investor, no matter what stage they are, keep an eye on their immigration and the investment process.
All right. Thank you both. If you want more information, you can always reach out to me, WR Immigration. Here are some QR codes that you can scan if you're looking at it on your computer through YouTube. And here is all of our contact information with some QR codes to our LinkedIn pages. If you have questions for Ishaan or for Michael, for myself, please feel free to reach out and we would be happy to speak with you. Michael, Ishaan, thank you so much for coming and speaking with me today. And thanks everyone for joining. Hope you have a great day. Thank you for listening.
Thanks, everyone.
Thank you, Joey.
All right. Take care.